Please be seated.
Mine says Winthrop. Are you things right?
You know, we're focused on really important things like whether we're correctly identified here in these nameplates. So, be that as it may. This is the time set for oral arguments in the case of WEBB versus Farm Bureau Property and Casualty Insurance Company, our civil number 16-0299. Each side will have 20 minutes within which to present their arguments here this morning. We have read the briefs, we've been through the record, we've conferenced the case, so we are pretty familiar with the underlying facts and the issues that have been raised in this appeal. We are recording the proceedings both by audio and video. The video portion will be available on YouTube at some point in the next several days. So if you really want to see what you look like and how you did, have at it. Because we are recording it, however, I'd appreciate it if, as you approach the podium, you identify yourself and your client for purposes of that recording. With that, appellant may proceed.
Thank you, Your Honor. May it please the Court, I'm John Condrey, and I represent the defendant and appellant, Farm Bureau Property and Casualty Insurance Company. Also named as a party was Farm Bureau Financial Services, but that entity really was not involved in the case. The trial of this matter was fairly scattershot, at least on the part of plaintiff and appellee. And my comments today, subject, of course, to questions from the court, will be focused on two things: whether the investigation by Farm Bureau was reasonable, and whether the decision by the trial court to issue the what I'll call the Mendota jury instruction was error. And so first I'll address the reasonableness of the investigation by my client, which I think forms the basis of the jury's erroneous decision to find that my client committed bad faith, notwithstanding that it correctly determined that there was no coverage for this claim because Justin Webb did not reside at his mother's house at the time of the accident.
Is there an Arizona case that upholds a bad faith verdict based on a failure to reasonably investigate a claim where the claim was not covered?
No, there isn't. That was discussed in the context of our well, let me put it this way. In the absence of additional facts that would give rise to a separate obligation on the part of the insurance company. For example, there was one case, and forgive me, I have about 1,000 cases in my head. There was one case where it was determined at some point that there was not a coverage obligation, but that the court's failure to provide a defense during but that's a duty to defend case, which is separate from a first party case where we have an investigation that is undertaken promptly. The decision is made based on reasonable facts. Mr. Justin Webb identified that he did not live at his mother's home for purposes of obtaining separate insurance at the 39th Street property. He changed his address for the purpose of his driver's license. And what was known is that all of the information that we had or that my client had, overwhelmingly supported that Mr. Webb did not live at the residence where his mother did.
Just let me interrupt for a second, because you said something at the beginning. You said that you believe, or you're presuming, that the jury's finding in favor of the plaintiff as it relates to the bad faith claim of necessity is tied to the reasonableness or unreasonableness of the underlying investigation. And so my question is, putting that aside, maybe in the abstract, could the jury have based its decision on bad faith on something else?
No.
They were instructed about the carrier's obligation to give the insured's interest equal consideration. That's a pretty well-established aspect of its obligation. Could an argument, this is even the way to say it, but if the carrier's interactions with the insured were so egregious, could that form a basis for a bad faith claim separate and apart from the reasonableness of the investigation?
In the context of a first-party claim? Yes. I don't think so, Your Honor, and I'll explain why. Because, and it might be that if the claims investigator went and beat the person up or something like that, something horrible like that, we would be facing a different situation. But if you have a situation where what the equal consideration argument is, do I weigh the claims of the insured at least equally with, my obligations to evaluate the claim and make a decision? And so if I don't make it so clear that my weighing of those obligations is so much in my favor, such that my investigation is not reasonable. In other words, you can't have one without the other, in my opinion, Your Honor, because all that my client did before it denied the claim is it evaluated whether there was coverage.
Set aside the investigation.
Set
aside the investigation. In another case, well, let's say in this case.
In this case, I'm sorry.
She testified 2 years later, after the fact. She reaches out to Farm Bureau and says, tell me again why specifically you denied the claim. Give me copies of the statements. Give me all the evidence. And she says, I didn't hear back. I didn't get a full response from what I said. Could ignoring an insured under those circumstances be ground for a bad faith claim?
Well, I don't think that rises to the level of bad faith. But let's assume, for purpose of the hypothetical question, that she said, starting at the very beginning, not the 2-year delay, but from the very beginning of the denial, I start asking all types of questions as the insured, and the insurance company completely disregards me. There might be a potential because the insurance company has an obligation to treat its insured fairly. In this case, the evidence that was submitted was Ms. Webb says, I asked 3 times. The claims adjuster says, I mailed the information 3 times, the last time I did it by certified mail. So she did receive it. It was sent by certified mail the last time. And he says, Mr. Cratch testified that he sent this information. Now, the one thing that did not happen until the litigation occurred was that the recorded statements that were made, the one of Neloise Garcia, Miss Webb's mother, and Miss Webb were not transcribed, And it took an expert to be able to actually get once it was downloaded to the claims file, they couldn't just, undownload it. It just wasn't feasible for them to do it until discovery started and, a transcription was provided, then a transcription was obtained by counsel, and then, Farm Bureau with some assistance figured out how to make actual copies.
Yeah. There are marked exhibits. There are 2 letters, I think, in that time frame from Ms. Webb to Farm Bureau, and then there are the Farm Bureau claims agent's notes. But I didn't see any, in the record anyway, copies of correspondence from Farm Bureau responding to Ms. Webb, explaining we don't have recorded statements because this, that, and the other thing, or any communication.
Well, the testimony from Mr. Cratch was that he provided copies of the claim decision and other documents, not including the claim notes that had been requested by Ms. Webb. And he did that on 3 separate occasions.
He just sent them off without a cover letter?
Well, he thought that responded to her question.
Sent them off without a cover letter?
To be honest, Your Honor, I don't recall whether he sent them with a cover letter or not at this time. I know that when he sent it by certified mail, there was an exhibit that had the certified mail receipt.
Okay.
Judge Johnson posed the question about the interaction between the insured or having the insurance company respond to the insured's requests and whether that can be a basis. What about if the insurance company, as part of the claims investigation process, takes steps which somebody could say were intended to or did result in financial or emotional injury to the insured? And I thought about this as I was reading Mr. Treon's closing argument and his rebuttal argument, because it seemed to be focused almost entirely upon the fact that there was a referral of some sort made to the Department of Insurance.
Right, Your Honor. Well, that cannot form the basis for a finding of bad faith. And the reason
I
know you said that in your closing, but if you could.
Well, I can elaborate, Your Honor. That's not part of the claim process. So this is a statutory obligation that Mr. Culley, as an SIU investigator, when he believed that there was a potential that this was what he called a questionable claim, what Mr. Treon called potential fraud, that Mr. Culley had an obligation to provide that information to the Department of Insurance.
Do you happen to know the statute?
I don't, Your Honor, off the top of my head. I'm happy to find that for you. But Mr. Culley was not in – his involvement was performing claim investigation pursuant to instruction from the adjuster who was handling the claim. And when the evidence that he found, and frankly that the jury must have found in finding that there was no breach of contract, is that Luana Webb was lying. He didn't determine she must have been. He determined she might have been. She might have been intentionally not telling the truth in her claim. And so he provided that information to the Department of Insurance. What the Department of Insurance did is it wrote a letter, hey, we don't have time to look at every claim.
Is there evidence in the record of that, what the investigator actually filed or lodged with the Department of Insurance, the words the investigator used? Yes,
Your Honor, there is. There is a document that basically is reflected as a sheet that was actually submitted by Mr. Treon in the record that identifies what, kind of a form that was filled out by Mr. Culley, and then there was some kind of an email communication from Mr. Culley to somebody at the DOI concerning that.
In light of the time, perhaps you ought to move to your analysis of the applicability or inapplicability of the Mendota.
Well, Your Honor, I will do that quickly. I see that I have 6 minutes and I haven't started my argument, so I guess I'll address that very quickly, and I'll do it this way. Mendota was a completely different case with different facts, and the Judge Anderson made a critical error in allowing this instruction, because in Mendota, the issue specifically was determining whether the insured was a member of the household where he had obtained the insurance. And it specifically says the word, with respect to resident, Mendota states, the word resident embodies the concept of place connoting the physical or geographical location or locale where individuals reside or dwell. And in response to my objection to the instruction, where I explained that this was a completely different situation, the judge said, okay, and I'll just note that there wasn't a question of ambiguity. There wasn't a question of ambiguity. There was no definition of resident. And so I thought the instruction that I gave of Mendoza/Mendota type factors was appropriate for the jury to consider the parameters of what residence means in an insurance context. That was completely wrong.
So is it your position that the instruction was actually a misstatement of the law?
What it was a statement. Yes, it was a misstatement in this case, because the law is that an insurance company, if it wants to narrow or define a term, it's allowed to do that. And then the court will construe the language based on that plain language of the insurance policy. And here, there was a definition of household member. That was a defined term.
But your argument is not that the jury was misadvised about how to interpret the contract, because the jury found in your favor on that.
Right. Well,
your argument as to this instruction is that it improperly guided the jury about how to evaluate WEBB's claim that you breached your duty by failing to properly investigate.
That's absolutely correct.
Okay.
Because counsel, in closing argument, pounded on his argument again that Farm Bureau had not looked into what household member was, which is.
But you didn't object as to that.
Based on, I had objected concerning I didn't object to the argument because the argument's not evidence, but it misled the jury. It clearly misled the jury because the evidence was that an investigation that leads to the correct decision based on supportable facts that were developed then forms the basis for them determining bad faith. And I have 2 minutes and 53 seconds. I'd like to keep that for.
Thank you, Your Honors. My name is Dan Trigon. I'm here for Plaintiff Luana Webb. May it please the Court, she sends her regrets for not being here. She's visiting her son, Nicholas, who's still in the Army. She does want me to thank you for reviewing her materials. I would note that we're the cross appellants, and so we'll request to reserve 5 minutes for a rebuttal on cross appeal. Your Honors, let me start with one of the easiest questions, I think, to answer, which is whether there were other bases than the bad investigation that plaintiffs alleged that formed the basis of the bad faith finding. And there were no less than 10, including the fraud referral that was presented to the DOI on a lie The statute there is,
What are the ramifications of the fraud referral to Ms. Webb?
well, importantly, the fraud referral did not exist in a vacuum. It started with Mr. Cratch sending Ms. Webb a letter saying, we have witnesses, and your son had a renter's policy at the time of his death, in effect at the 39th Street house. That was false, and he agreed that it was false. Mr. Coley made that same false misrepresentation to the DOI and put that fraud referral there. Now,
What's the statute? You were going to say it.
yes, sorry, it's, I just scribbled it down. It's in our brief, and it is 20-466G.
Thank you.
That statute says that before an insurance company can make a fraud referral or should make a fraud referral to the DOI, it must arrive at a belief that fraud has been committed. Not just a question, not just a suspicion, but a belief. And Mr. Coley said he didn't really conclude she committed fraud, and Mr. Cratch, the lead adjuster on the case, said he didn't ever conclude that she had committed fraud either or made any false statements. This whole idea of Ms. Webb making a lie never once appeared in the claim file. These gentlemen never once documented one iota of suspicion that she was being dishonest. This is
Well, weren't they suspicious from the initial interview with the grandmother who said that Justin resided at her residence and then changed that while he was interviewing Miss Webb?
They were suspicious of Justin Webb from the first documents they looked at, which showed him to have criminal history and lots of accidents. And then they went
Noting an address elsewhere. Or
also noting an address at which he had previously lived as a child until he was in high school, which Farm Bureau never figured out. They went to talk to Grandma, Mrs. Garcia, down the street around the corner, and she said, yes, he lived here too. Mr. Coley, this is kind of important, says, did he live here too? Well, right there is an acknowledgement that under, I think it's mid-century and Mendota, a person can have two residences for insurance purposes and still be considered an underinsured person. But he asked her, did he live here too? If you really read that transcript, you'll see that there is no focus on from when to when did he live here. She just says, yeah, he lived here. And then there's this long discussion of when he started living there. She says it was after 2008 when he returned from Iraq. And Mom says, yeah, her first statement to Farm Bureau was he lived here part-time. He was in between houses at any given time, but his primary home base that he always kept was with his mother, and that was her unrebutted testimony. And that's why all of his stuff was there, as visualized by his brother.
unrebutted testimony?
Yeah,
Wasn't
this is
there
her-
testimony from Justin's brother that he was not residing there and that Miss Webb had other reasons for now changing the facts?
He had no personal knowledge of that. He had not been to his mother's house in the 8 months between when Justin was excluded from grandparents' house for his drug activity until his death. Sam Phillips had no personal knowledge of that. The only eyewitnesses on that point were Mr. Height, the cousin, Richard Height, who, of course, defense points out had a felony conviction and was doing drugs with Justin. But Mr. Height said that. Justin was living at his mom's house and would go to his girlfriend's house and stay there, too, with his backpack. But otherwise, all of his stuff was at the mom's house. Ms. Webb's son, Nicholas, who, it should be pointed out, is that we pointed this out in our papers, that Mr. Nicholas Webb is an Army sergeant, I believe, with the nation's highest security clearance, and he testified under oath that when he was at the house in July of 2011, all of Justin's stuff was at Luana Webb's house. He stayed also at Grandma's house. None of Justin Webb's stuff was at Grandma's house down the street. So the most temporal time period of witnesses that show the unrebutted nature of the testimony that Justin was a resident member of Webb's household between July 2011 and his death in August 2011 was Nicholas Webb and Richard Height. And to answer your question, Your Honor, Mr. Sam Phillips obviously had a horrible axe to grind with his mother. and he had admitted that he had never been to that house in those 8 months before Justin passed. What came in evidence actually was Mr. Phillips testifying about Justin's hearsay statement to Mr. Phillips, where Justin said, "I live with my girlfriend Blanca." Now, the court had ruled that was inadmissible hearsay. And then in the meatball surgery that occurs with video deposition testimony, that snippet didn't get snipped and end up on the cutting room floor. It came in. We objected. The court said, move on. But that was in evidence. It was ruled excluded, rank, unverifiable hearsay that Sam Phillips, who had an obvious axe to grind with his mom, said, "You got an evidence, we dealt with it." But the fact remains that it is unrebutted that the only eyewitnesses to where Justin lived in the 11 months before he passed, which is the relevant time frame, that is at the time of his death, were his mother, Nicholas Webb, and Richard Height, and actually his aunt, Miss Powell.
I have a concern that the cases do not support a bad faith verdict against an insurer that is premised solely or that's premised on a failure to properly investigate a claim that's not a covered claim. So what I'm interested in and would encourage you to do, I mean, if you've got a case that says that, then tell me, but I don't think that there is one. Therefore, continue on in listing the evidence that you think would support the bad faith claim or the bad faith verdict that is not relating to what you think was a bad investigation.
Okay. Item 1. Mr. Culley presented false information to the Department of Insurance that Mr. Justin Webb had a renter's policy in effect at the time of his death. That policy was canceled by Justin Webb in 2009, and he died in August 2011. That's a false statement. Number 2, he misled in the fraud referral by claiming that Justin was not a named insured. So what? It doesn't matter that he's not a named insured to get underinsured benefit law. Number 3, Mr. Cratch had a false statement in his November 23, 2011 letter claiming to have witnesses, plural, and renter's policy at 39th Street in effect at the time of his death. So he's telling Ms. Webb as a blatant falsehood, and he's not giving her the documents. That's number 4. He's not giving her the documents. Number 5, they don't give her the recorded statement of mom. This was the first I've heard that there was some kind of computer problem where they couldn't download the information and give her the recording. It's not in the record, and if that were true, then the answer from Mr. Cratch in response to her letters after she got over her grief and dealt with her depression should have been, okay, we can't produce these recorded statements, so give us a week or two and you can extend the statute, don't sue us, or we'll extend the time for service or whatever it takes to make sure you are satisfied as an insured and we're treating you properly, to give you a chance to see what your mom said. Additional information is they withheld information, additional basis for the bad faith. They withheld throughout this whole time. They never gave her a copy of this photograph of the Discover letter. Recall that when Mr. Culley went to Ms. Webb's house to interview her, he knew that he had seen a Discover card mailing at Grandma's house down the street, and he didn't tell her that. One reasonable thing would have been to do when she says, well, he lived here, he could have said, well, I just saw this Discover mailing down the street. She could have walked down there with him and said, Mom, where's the Discover card? Is that an account that I don't know about where Justin has claimed this as an address, or is it a solicitation from the fact that he lived there until just recently as a teenager in high school, and then also put that as his formal address? Recall our expert testified that what people use as their formal addresses is really one of the least indicators of where they might be residing oftentimes. No reservation of rights letter. That's pre-investigation. This is the kind of thing where an insurance company puts an insured on notice. We think that there might not be coverage.
How does that matter here, though, when there wasn't as if there was a duty to defend? I mean, so what?
Well, it would have put Ms. Webb on notice that maybe she needed to get a lawyer to figure out what she needed to show an insurance company, the facts related to showing her son lived there. She thinks having the adjuster come into the house and see his clothing should be an adequate proof level, but a lawyer might think differently. That's the point of the reservation of rights, so that there's not a secret investigation going on behind the insurer's back, which is not an equal consideration.
Is there a case that talks about the need to send a reservation of rights letter where there's not a duty to defend?
I do not have that case, but they're in their pre-investigation stage, and that's where they're figuring out, do we think that this person is a resident member of the household, and that's why they have to give the insured fair notice. Our experts certainly said that was a standard in the industry. They breached it, and it was an aspect of their bad faith. There were other aspects too, where post-decision, Farm Bureau rejected its own investigator's action plan. He had several things he said he needed to go do, and they said, we got to know, move on. One of those things was contacting USAA to determine apparently exactly when the renter's policy at 39th Street had been terminated, or if it was still in effect. He didn't do that. And we found that information by subpoenaing USAA, and it shows right there that where Mr. Colling and Mr. Crash are claiming that this policy at a renter's house, at a renter's location down the street was in effect when he died, was terminated 2 years earlier, and yet he's making these false statements. The jury's verdict, though, said, with respect to the final point I make about the basis for bad faith on the processing, that the jury found bad faith, and they said, Farm Bureau, pay this woman's attorney's fees, all the expenses of litigation. And that was part of our argument here, which is once she gets over her grief, she reaches out to Farm Bureau and says, show me, what are you talking about? Because I know my son lived with me. Yeah, he went off to girlfriends, etc., spent time at grandma's, but show me and give me more time. What are you talking about, etc.? And they don't, and so that speaks to the basis of their decision. Let me answer your first question about the case law that talks about this.
What case supports this?
DEES. It's the DEES, D-E-E-S-E. Yeah, okay, sorry.
I'm sorry,
Okay.
but that's not a failure to investigate a claim that's not covered case.
No, but the law says there that unequivocally, even if there's no coverage found or owed after whatever the contemplation is done by the insurance company, a cause of action for bad faith still lies. And
But
critically,
that wasn't based on a failure to investigate.
But it made clear that it's a blanket rule on all of these types of cases. Farm Bureau is essentially trying to make new law on a case that it shouldn't, and it didn't try below. None of this stuff was raised below. It wasn't raised in Farm Bureau's JMOL motions. It wasn't raised in its breach of contract motions. It wasn't the frame of the case. It never raised these arguments below, and frankly, with respect to its complaint about the instruction, all waived. My argument that argued that all of what Farm Bureau did here with its instruction, I didn't pound on this issue whatsoever. I mentioned it once, but it was all part of the milieu of bad acts this company did that constituted a bad investigation and horrible processing acts. Not giving this lady information, not telling her what information it had, withholding her mother's recorded statement, false statements to the DOI. All of those bases are part of the jury's verdict. Not giving her some more time, not giving her the reservation of rights. We went through this at length. It wasn't
Counsel,
remotely scattershot either.
Independent of the issue of the false, what you characterize as false representations to DOI, what other implications might flow from the referral? Your expert testified that this was somehow negative or derogatory. What are the consequences aside from this litigation?
Good question, because Mr. Culley submitted his DOI referral through the ISO portal, Insurance Services Organization. That's the big brother that sits behind all insurance companies as a database of every single person's claim on any single subject. In fact, answering another question, what documents did Mr. Crash send?
Before we get too far from it, So it's submitted to the ISO, but so what happens? There's not been a determination that she actually committed fraud.
The DOI never pursued the investigation. That submission itself sits on her permanent record with the ISO. She goes to apply for insurance in the future, and our expert testified that another insurance company will see that she has been submitted for fraud, and that's a black mark on her.
Even though there's been no determination that she actually committed fraud?
Yep. That's his testimony. He worked for years in Nationwide Insurance. He's a lawyer also and has worked in this field for 35 years, and that was his testimony. So that black mark is on her. Imagine, the damage we would have today if the DOI had picked it up and prosecuted her, and there was this false statement that she had lied since apparently he had a renter's policy that was in effect at the time of his death down the street, when in fact we now know that wasn't true.
So what you're saying is that I suspect there must be many submissions made where there is no prosecution.
I don't think so. I practice a lot of bad faith law, and I see very few referrals for fraud because of that high standard. The insurance company has to believe, quote unquote, believe fraud was committed, not just have a question about it, not just think it might have happened. And here is based on false information. Well, final point before I say my 2 minutes and 40 seconds. Somebody asked about what documents did Mr. Cratch send to Ms. Webb in response to her request in 2014. The ISO documents, which are an exhibit, and if you read those, you'll quickly see they're almost unintelligible. It takes somebody to explain them to you. And the police record documents. Did not send a photograph of the Discover card mailing, did not send the recorded statement, did not answer her questions, did not give her a list, blew her off.
Did it send her a copy of the policy she asked for?
No, not to my, no, I don't know about that. I can't speak to that policy or not. But in his first letters denying the claim, he never includes resident member of the household. That first letter in November 7, 2011, we're denying your claim. Have a nice day. There's no language provided there about on what basis, including the policy language. I'll reserve my 1 minute, 47 seconds. Thank you.
All right, counsel, thank you. Mr. Condrey.
I invite the court to take a look at Mr. Frangiamore's testimony. What you would find is that he doesn't know anything about Arizona law except for 2 cases that were provided to him by counsel. There is not testimony in there about this referral sits as a black mark forever and ever on Luana Webb. And the statement by counsel about what he knows from his practice is not in the record with respect to this case. The statement with respect to lies by Mr. Culley are just inaccurate. One of the lies that counsel says is, he says, the letter goes out that says we have witnesses and a renter's policy. The witnesses were Officer Guilford, who testified at trial, who confirmed that he talked to Justin Webb, who said that his residence was at the 39th Street property. That was in 2011. Then we have Neloise Garcia, also a witness, who said unequivocally, by the way, if you look, I actually, in my brief, I go through the entire interview, and it is absolutely clear from that entire interview that she says, Justin lived with me right after high school, and he lived with me when he got back from the Marine Corps. In contrast to the testimony of Luana Webb and the statement of Luana Webb in her recorded statement that he always lived with me. That's what it says in the complaint of plaintiffs. That's what she testified to at trial. That's where she browbeat her mother in the recorded statement to recognize that she was actually being recorded. And the reason that Neloise Garcia said, hey, I don't know what you're talking about, is because she didn't know that the statement had been recorded. The importance of the evidence about the USAA policy was that it supports that Justin Webb lived somewhere else during some significant period of time. again, in contrast to the testimony of Luana Webb. That those ISO documents, which are absolutely clear, show that every time he gets arrested, and the arrest documents show every time he gets arrested, he identifies and shows his driver's license. So I see that my time is past, and I don't want to continue. But if there are any questions, I'm happy to answer them.
Thank you, counsel.
Thank you, Your Honor.
So this is on the cross appeal?
Briefly rebutting the claims about the record, Mr. Officer Guilford was represented to have visited or gone to the 39th Street, and he never testified to that. He said he didn't go there to verify, as was represented. That was the lack of witnesses. Later, we obtained testimony that showed that in 2011, when Mrs. Garcia was interviewed, as reflected by her not remembering.
Relate to the cross appeal.
Oh, I'm sorry. Yeah, I was too busy rebutting the facts. I would ask Your Honors to look at the Deese case again, particularly Martone's dissent, which relates to this question of how the bad faith law applies to where there's no breach of contract. Our cross appeal, I think, when you look at the timing of the evidence, shows that the last 8 months, the only evidence of where he lived was at Luana Webb's house, and everything else counsel just talked about was stale documentation. Thank you.
Thank you, counsel. We'll take this matter under advisement and issue a ruling in due course. We do appreciate the briefs submitted in this appeal and the statements made to this morning at argument. With that, we'll stand at recess.